I want you to close your eyes for a second. We are leaving the present day, and we are dropping you right into the sensory overload of Manila.
But not the Manila you might know today.
No, not at all. We are dialing the clock way back to September 11th, 1908. We're in the district of Ermita.
So you have to erase the skyscrapers, erase the jeepneys, and definitely erase the gridlock traffic as we know it.
Right.
There are no engines humming, no exhaust fumes. The soundtrack of the city is completely different. It's the clip-clop of hooves, the creaking of wood, the shouting of drivers, the rattle of iron wheels on cobblestones.
It's a totally different rhythm. We're standing on Calle Real. It's a bustling morning, but the whole pace is dictated by horses, not horsepower.
And in the middle of all this, you've got a woman named Carmen Martinez.
She's riding in a caramata, which for anyone who hasn't seen old photos, is a two-wheeled, horse-drawn carriage.
It was basically the taxi of the era, and she's in there with her child just heading down the street.
And on the other side of this equation, coming from the opposite direction, you have the heavy-duty technology of the day, a delivery wagon.
This isn't a passenger vehicle.
Yeah.
It's a work truck, you know. It belongs to a man named William Van Buskirk, and it's full of fodder-heavy sacks of animal feed.
And it is coming down the street, heading straight toward Carmen.
Now, usually in 1908 or today, when you see a large vehicle coming at you, you instinctively look for the driver. You try to make eye contact.
Right. You're looking for intention. But as this heavy delivery wagon barrels down Calle Real, Carmen's driver looks up and realizes something terrifying.
There's no one there.
The driver's seat is empty.
Which is the absolute nightmare scenario. A runaway team of horses hauling a heavy payload with zero human guidance.
Carmen's driver reacts instantly. He does exactly what the traffic laws of 1908 said to do. He pulls over to the left, and you have to remember, traffic flow was different than under the American administration.
So he hugs the curb and stops. He's bracing for impact.
He's making himself as small a target as possible, hoping this runaway train will just pass them by.
But physics and the horses had other plans. The wagon doesn't pass, it crashes right into them.
And it's a violent wreck. This isn't a fender bender. Carmen gets a serious cut on her head, the caramata is smashed up, the harness is destroyed. It's a total disaster.
And naturally, this leads to a lawsuit. Carmen and her husband sue William Van Buskirk, the owner of the wagon.
And that lawsuit becomes Martinez v. Van Buskirk. It's a landmark decision from the Philippine Supreme Court in 1910.
And that is our mission for this deep dive.
Exactly. We aren't just talking about a traffic accident from over a century ago. We're unpacking a legal battle that answers a question that sounds simple, but is actually incredibly thorny.
It's a question that really challenges our definition of responsibility.
The question is, if a delivery man leaves his horses unhitched to make a delivery, which, spoiler alert, everyone did back then, and they run away and cause a disaster, is the owner legally on the hook?
It's a classic conflict between safety and reality. The lower court looked at the crash and said, yes, absolutely, pay the woman. They ordered Van Buskirk to pay 442 pesos and 50 centavos.
But the Supreme Court took a look at the very same facts and said, not so fast.
And that reversal is what this is all about. Because to get there, the court had to define three really fascinating concepts: social custom, negligence, and a phrase that I know you love.
It is my favorite legal term of all time. The diligence of a good father of a family.
It's a very evocative phrase, isn't it? But before we get into the philosophy of what makes a good father in the eyes of the law, we really need to reconstruct the scene.
Right, because the why matters here. My first instinct is negligence. If I leave my car rolling down a hill in neutral with no one inside, I'm negligent. End of story.
Of course.
So where was Van Buskirk's driver? Was he at a bar? Was he asleep under a tree?
No, and this is the absolute crux of the defense. The driver, the cochero, was actually working. He was delivering forage to the Paco livery stable on Calle Heron.
Okay, so picture the logistics. He has a wagon full of heavy feed. He has to get it off the wagon and into the stable.
Exactly. He physically has to get up, go to the back, and move the cargo. He can't sit in the driver's seat holding the reins and unload at the same time.
He's a one-man operation.
Right. So he did what he always did. He took the driving lines, the reins, and tied them securely to the front of the wagon. Then he physically went inside the wagon to start unloading.
So the horses are just standing there. They are unhitched, meaning not tied to a post, but the reins are secured to the vehicle itself. He's in the back working. It sounds precarious, but I guess functional.
It was. Until something else happened.
What went wrong?
It wasn't something he did directly. This is where the story gets cinematic. While he was unloading, another vehicle drove past his wagon.
Okay.
And the driver of that vehicle cracked a whip.
A whip crack.
A loud, sharp whip crack, and probably some shouting. Just a sudden, aggressive noise. And it spooked Van Buskirk's horses.
Horses are flight animals. They hear a crack like that, they panic.
Exactly. They bolted. Now, you have to remember, the cochero is inside the wagon.
So what happens to him?
The sources say that when the horses jerked forward, he was thrown right out the back door onto the ground. He actually tried to grab the reins, but the jolt was too much.
So he's on the ground, probably bruised, just watching his wagon speed away.
And the horses take off running, and a few blocks later, they crash into Carmen's carriage.
Okay. So when this goes to trial, the lower court looks at this and says, look, your horses hit this lady, you left them unhitched, you were negligent, pay up.
And they base that on the Civil Code, specifically Article 1902 and Article 1903. These are the pillars of civil liability in this system.
Let's break those down because this is the legal machinery at work. Article 1902 seems pretty straightforward.
It is. Article 1902 is basically the you break it, you buy it rule. It says if you, through fault or negligence, cause damage to someone else, you are obliged to repair it.
Simple enough. But Van Buskirk wasn't driving. He wasn't even there.
That's where Article 1903 comes in. This is the concept of vicarious liability. The law says the obligation to pay for damages isn't just for your own acts, but for the acts of people you are responsible for.
So if I own a pizza shop and my delivery driver crashes into a mailbox, I'm in trouble.
Correct. Owners and directors are liable for damages caused by their employees while they're on the job. But, and this is a huge but, there's an escape hatch.
I was going to ask, it seems unfair to be automatically liable if you weren't the one who messed up.
The law agrees. The final paragraph of Article 1903 says that this liability ceases, it goes away completely, if the employer proves they employed all the diligence of a good father of a family to avoid the damage.
There it is, the diligence of a good father of a family. It sounds so old-fashioned, like something out of a Victorian novel.
It comes from Roman law bonus pater familias.
Yeah.
And it doesn't mean you literally have to be a dad, it just establishes a standard of reasonable care.
So it's asking, did you act like a prudent, responsible person would act in that situation? Did you hire good people? Give them good equipment?
That's it, exactly. So the debate in the Supreme Court wasn't really about the crash. The debate was, did Van Buskirk and his driver act like good fathers? Or were they reckless by leaving those horses unhitched?
Precisely. And this is where the defense Van Buskirk's legal team built a really interesting argument. They called it the gentle horse theory.
The gentle horse theory. It sounds like a children's book. The gentle horse who went to court.
It does, but it was dead serious evidence. They presented proof that these specific horses were gentle and tractable.
They weren't wild Mustangs. They were reliable, working animals.
And what about the driver? Was he some rookie?
No, they proved the cochero was experienced, capable, and a good servant. He'd been driving one of the horses for years and the other for months.
Had they ever run away before?
Never. The defense's key point was that the cochero had a habit, a routine, of leaving them unhitched exactly like this every single day.
And in all that time, there had never been an accident.
Not once.
See, I have to pause here. This is where it gets tricky for me. Just because you do something 1,000 times and don't get hurt, does that mean it's safe?
That's the hard question, isn't it?
I mean, I could drive without a seatbelt 1,000 times and be fine, but the one time I crash, I was still negligent for not wearing it, right? I feel like the I always do this excuse shouldn't fly.
That is exactly what the court had to wrestle with. Does a history of safety excuse a behavior that looks risky? To answer that, Justice Moreland, who wrote the decision, looked at something bigger than just these two horses. He looked at social custom.
Social custom. Essentially, everyone's doing it.
In a way, yes. The evidence showed that leaving horses unhitched while unloading was the universal practice for cocheros in Manila. Every single delivery driver did it this way.
But why does that matter legally? Just because everyone jumps off a bridge doesn't make it a good idea.
Because the law acts within the context of society. Justice Moreland argued that acts which aren't illegal and aren't inherently destructive and have been accepted by society for a long time. Well, they can't suddenly be called negligence just because an accident happened once.
So if society says this is okay, the court shouldn't step in and say, no, it's not.
Generally, yes.
Yeah.
But here's the deeper layer. The court pointed out that society permits these customs because they are beneficial. This is a utilitarian argument. It's about efficiency versus safety.
How so?
Well, think about the alternative. If the court ruled that leaving horses unhitched is negligence, then every delivery driver would have to hire a second person.
Oh, I see. One to unload and one to just sit there and hold the reins. The
Yeah.
labor cost doubles immediately.
Right. Or deliveries take twice as long because you have to tie up at a post far away and carry everything by hand. The cost of everything goes up.
So business would grind to a halt.
It simply wouldn't be efficient. There's actually a quote in the source material where they cite a British case, Hayman v. Hewitt, and Lord Kenyon said it would be impossible for the business of the metropolis to go on.
That is a fascinating perspective. It's basically saying we as a society accept a tiny risk of a runaway horse because we need our animal feed delivered efficiently and cheaply.
It's a calculated risk. The court's opinion was that you shouldn't be punished for following a custom that the public has accepted for decades. Justice Moreland called custom the strongest of all civil forces.
The strongest of all civil forces. That is heavy. It implies that what people actually do matters almost as much as what the rule book says.
In the context of defining negligence, yes. Negligence is doing what a prudent person wouldn't do. But if every prudent person leaves their horse unhitched to unload, then doing so isn't negligent. It's just normal.
But wait, the Philippine Supreme Court wasn't just deciding this in a vacuum, were they? They were looking at international laws, too.
Oh, absolutely. This was 1910, so American jurisprudence was very influential, as was Spanish law. They cited cases from New York, New Jersey, Vermont. They wanted to show this wasn't just a Manila thing.
And did those courts agree with this gentle horse theory?
They generally did. There was a case, Lynch v. Nurden, and another, Bells v. Kellner. The consensus was that leaving a gentle horse unhitched isn't negligence per se. It depends entirely on the horse.
So the animal's personality is on trial here.
It is. There was another case cited, Griggs v. Fleckenstein, that made this distinction very clear. Whether it's negligence depends on the disposition of the horse. If you leave a wild stallion unhitched, you're negligent.
Because you know it's probably going to run.
Exactly. But if you leave an old, tired workhorse unhitched, you're probably fine. The good father knows his horses. Van Buskirk's horses were known to be calm, so he acted reasonably.
So Van Buskirk's defense that the horses were gentle and tractable was actually the linchpin of the whole case. If those horses had a history of biting or running, he loses.
He loses immediately, no question.
I want to bring up another legal term that appears in the documents, because it sounds like it should have sunk Van Buskirk. Res ipsa loquitur.
Ah, yes. Latin for the thing speaks for itself.
Usually, if I see a wagon barreling down the street with no driver, the thing speaks for itself. Someone messed up. It's like a piano falling out of a window. We don't need to know who pushed it to know someone was negligent.
That's the usual application. It creates a presumption of negligence. It shifts the burden. So instead of the victim having to prove you were sloppy, you have to prove you were careful.
So why didn't that apply here? The wagon ran away. The thing spoke.
The court ruled that res ipsa loquitur only creates a prima facie case. That means it's just a first impression. It's the starting line, not the finish line.
It invites the defendant to explain what happened.
And Van Buskirk did explain. This brings us back to the whip crack. Once he proved the specific circumstances, the gentle horses, the driver's experience, and crucially, that sudden external noise, that presumption of negligence was destroyed.
It was the whip crack that really saved him, wasn't it?
It was a huge factor. The accident was caused by an unforeseen external event. The cochero couldn't have predicted that some random person would drive by and crack a whip right at that specific second.
So if there was no whip crack and the horses just decided to wander off,
it's a much, much murkier case. If gentle horses wander off for no reason, then maybe they weren't so gentle after all. But because there was a clear cause that wasn't the driver, the court felt comfortable saying this was an accident, not negligence.
So let's get to the final verdict.
The Supreme Court reversed the lower court's judgment. William Van Buskirk and his driver were found not negligent.
So Carmen Ongda Martinez, she got nothing.
In this specific suit against Van Buskirk, yes, she lost the appeal. The court said the act was not unreasonable or imprudent given the standards and customs of the time.
That feels harsh. I mean, she was just riding down the street following the rules and got smashed by a wagon. Was it a unanimous decision?
Actually, no. Justice Torres dissented. He voted to affirm the lower court's ruling, which means he thought Van Buskirk should pay.
But he didn't write a long explanation why, right?
No, the record just notes his dissent. But it shows that even among the judges, this was not an open and shut case. It was a choice between strict liability and practical custom.
Protecting the victim at all costs versus protecting the flow of commerce.
And the majority chose commerce.
It really is a story about the tension between safety and efficiency. We sacrificed a bit of safety on Collier Real so that feed could be delivered cheaply.
And about the definition of a reasonable person, the court essentially said accidents sometimes happen. Just because an injury occurred doesn't mean someone is legally at fault, especially if they were just doing what everyone else does.
Which is a bit of a hard pill to swallow if you're the one who got hit by the wagon.
Absolutely. From the victim's perspective, it feels deeply unfair. But from the legal system's perspective, holding Van Buskirk liable would have meant overturning the entire logistics system of Manila overnight.
The business of the metropolis must go on.
Precisely. The law is often pragmatic. It has to look at the macro effect. If they punish Van Buskirk, they punish every delivery company in the Philippines.
So, to recap for now, we have a crash in 1908, a defense built on the idea that my horses are good boys, and a Supreme Court ruling that elevated social custom to a legitimate defense against negligence.
That's the nutshell. If society accepts the risk because the practice is useful, the courts are hesitant to penalize it.
This brings me to something I've been thinking about. We don't use horses anymore, but we definitely have customs that are technically risky but universally accepted.
We absolutely do. Human nature hasn't changed, just the technology.
I'm thinking about things like glancing at your GPS while driving, or walking across the street while staring at your phone.
Oh, definitely. Or speeding up when the light turns yellow instead of slowing down.
Exactly. Legally, you should be fully focused or slowing down. The code says don't be distracted. But practically, everyone's checking Waze.
So let's apply the Van Buskirk logic. If everyone does it stop being negligent? If I crash because I was looking at a map on my screen, can I say, well, Your Honor, it's the universal custom of the metropolis to navigate with an app, otherwise business would grind to a halt?
That is the million-dollar question. Where do we draw the line today? In 1910, the efficiency of unloading feed outweighed the risk of a runaway horse.
Today, courts have to decide if the efficiency of checking an email outweighs the risk of distracted driving.
The court in 1910 said custom is the strongest of civil forces. I wonder if that force is still as strong today, or if our tolerance for accidents has just gone way down.
I think we demand a much higher diligence of a good father today than they did on Call Royale. We expect systems to be fail-safe. We have insurance, sensors, but the core tension between what the law says on paper and what people actually do is exactly the same.
It makes you wonder what things we do today that future generations will look back on and just say, I can't believe they all did that.
Probably quite a few things.
Something to chew on the next time you see someone doing something risky just because everyone else is doing it.
Just because it's custom doesn't mean it's safe. Sometimes the custom needs to change.
That's it for this deep dive into Martinez v. Van Buskirk. Thanks for riding along with us.
Drive safe. And maybe hit your horses.